Midnight appointments. A midnight appointment refers to those appointments made within 2 months immediately prior to the next presidential election. Midnight appointments are prohibited under Article 7, Section 15 of the Constitution, which provides that 2 months immediately before the next presidential elections and up to the end of his term, a president or acting president shall not make appointments except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Now, what is the rationale of the prohibition against midnight appointments? Midnight appointments are prohibited because an outgoing president is duty-bound to prepare for the orderly transfer of authority to the incoming president, and he or she should not do acts which he or she ought to know would embarrass or obstruct the policies of his or her successor. An outgoing president should not deprive the new administration of an opportunity to make the corresponding appointments. Now, what is the coverage of the prohibition against midnight appointments? The prohibition on midnight appointments only applies to presidential appointments. It does not apply to appointments made by local chief executives. Nevertheless, the Civil Service Commission has the power to promulgate rules and regulations to professionalize the civil service. It may issue rules and regulations prohibiting local chief executives from making appointments during the last days of their tenure. Appointments of local chief executives must conform to these civil service rules and regulations in order to be valid. Now, the prohibition under Section 15, Article 7 of the Constitution does not apply to appointments to fill a vacancy in the Supreme Court or to other appointments to the judiciary. The court ruled in the case of De Castro versus Judicial and Bar Council that the Constitutional Commission confined the prohibition to appointments made in the executive department. The framers did not need to extend the prohibition to appointments in the judiciary because their establishment of the Judicial and Bar Council and their subjecting the nomination and screening of candidates for judicial positions to the unhurried and deliberate prior process of the Judicial and Bar Council ensured that there would no longer be midnight appointments to the judiciary. Said ruling modified the former rule espoused in INRE Appointment of Valenzuela, AM number 98-0501 in 1998, that the provision on midnight appointments applies to the judiciary.